The Monarchy of New Zealand, also referred to as the Crown in Right of New Zealand, Her Majesty in Right of New Zealand, or the Queen in Right of New Zealand, is the constitutional system of government in which a hereditary monarch is the sovereign and head of state of New Zealand, forming the core of the country's Westminster-style parliamentary democracy. The Crown is thus the foundation of the executive, legislative, and judicial branches of the New Zealand government, while Royal Assent and the Royal Sign Manual are required to enact laws, letters patent and orders in council. The authority for these acts stems from the New Zealand populace and, within the conventional stipulations of constitutional monarchy, the sovereign's direct participation in any of these areas of governance is limited, with most related powers entrusted for exercise by the elected parliamentarians, the ministers of the Crown generally drawn from amongst them, and the judges and justices of the peace. The New Zealand monarchy has its roots in the British Crown, from which it has evolved to become a distinctly New Zealand institution, represented by unique symbols. New Zealand's monarch, since the 6th of February 1952, Queen Elizabeth II, is today shared equally with 15 other countries within the Commonwealth of Nations, all being independent and the monarchy of each legally distinct. For New Zealand, the current monarch is officially titled Queen of New Zealand, and she, her consort, and other members of the New Zealand royal family undertake various public and private functions across New Zealand and on behalf of the country abroad. However, the Queen is the only member of the royal family with any constitutional role, while several powers of the sovereigns are alone, because she lives predominantly in the United Kingdom. Most of the royal constitutional and ceremonial duties in the realm of New Zealand are carried out by the Queen's viceroys, the Governor-General in New Zealand and Niue, and the Queen's representative in the Cook Islands. As the territories of the realm of New Zealand are not sovereign, they do not have a viceregal representation. International and domestic aspects. New Zealand shares the same monarch with each of 15 monarchies in the 54-member Commonwealth of Nations, a grouping known informally as the Commonwealth Realms. The emergence of this arrangement paralleled the evolution of New Zealand nationalism following the end of the First World War and culminated in the passage of the Statute of Westminster in 1931. Since when the pan-national crown has had both a shared and separate character, and the sovereign's role as monarch of New Zealand has been distinct to his or her position as monarch of the United Kingdom. The monarchy thus ceased to be an exclusively British institution, and in New Zealand became a New Zealand establishment, though it is still often misnomered as British in both legal and common language for reasons historical, political and of convenience. This conflicts with not only the government's recognition and promotion of a distinctly New Zealand crown, but also the sovereign's distinct New Zealand title. Effective with the Constitution Act 1986, no British or other realm government can advise the sovereign on any matters pertinent to New Zealand, meaning that on all matters of the New Zealand state, the monarch is advised solely by New Zealand ministers of the Crown. As the monarch lives predominantly outside of New Zealand, one of the most important of these state duties carried out on the advice of the Prime Minister of New Zealand is the appointment of the Governor-General, who performs most of the Queen's domestic duties in her absence. All royal powers in New Zealand may be carried out by both the monarch and Governor-General, and, in New Zealand law, the offices of monarch and Governor-General are fully interchangeable, mention of one always simultaneously including the other. Cost. The sovereign similarly only draws from New Zealand coffers for support in the performance of her duties when in New Zealand or acting as Queen of New Zealand abroad. New Zealanders do not pay any money to the Queen or any other member of the royal family, either towards personal income or to support royal residences outside of New Zealand. Normally, tax dollars pay only for the costs associated with the Governor-General and Queen's representative as instruments of the Queen's authority, including travel, security, residences, offices, ceremonies, and the like. Supporters of the monarchy argue it costs New Zealand taxpayers only a small outlay for royal engagements and tours and the expenses of the Governor-General's establishment. Monarchy New Zealand states his figure is about $1 per person per year, about $4.3 million per annum. An analysis by New Zealand Republic of the 2010 budget claimed the office of Governor-General costs New Zealand taxpayers about $7.6 million in ongoing costs and $11 million for government house upgrades. Figures Monarchy New Zealand claimed had been arbitrarily inflated by New Zealand Republic. Succession. Succession is for persons born before 28 October 2011, governed by male preference cognatic primogeniture, and, for those born after the 28th of October 2011, by absolute primogeniture, wherein succession passes to an individual's children according to birth order, regardless of gender. The succession is governed by the Act of Settlement 1701, Bill of Rights 1689, and Royal Succession Act 2013, legislation that also limits the succession to the natural, legitimate descendants of Sophia, Electress of Hanover, and stipulates that the monarch cannot be a Roman Catholic and must be in communion with the Church of England upon ascending the throne, though via adopting the Statute of Westminster and the Imperial Laws Application Act 1988. These constitutional documents as they apply to New Zealand now lie within the full control of the New Zealand Parliament. New Zealand also agreed not to change its rules of succession without the unanimous consent of the other realms, unless explicitly leaving the shared monarchy relationship a situation that applies symmetrically in all the other realms, including the United Kingdom, and has been likened to a treaty amongst these countries. Thus, New Zealand's line of succession remains identical to that of the United Kingdom. As such, the rules for succession are not fixed, but may be changed by a constitutional amendment. The Constitution Act 1986 specifies that should a regent be installed in the United Kingdom, that individual will carry out the functions of the monarch of New Zealand. Upon a demise of the crown, the late sovereign's heir immediately and automatically succeeds, without any need for confirmation or further ceremony. Hence arises the phrase, "The king is dead. Long live the king." Quote, "It is customary, though, for the accession of the new monarch to be publicly proclaimed by the Governor-General on behalf of the Executive Council of New Zealand. Following an appropriate period of mourning, the monarch is also crowned in the United Kingdom in an ancient ritual, but one not necessarily for a sovereign to reign. Other than a transfer of all royal powers and functions to the new monarch from his or her predecessor, no other law or office is affected, as all references in legislation to previous monarchs, whether in the masculine or feminine, continue to mean the reigning sovereign of New Zealand. After an individual ascends the throne, he or she typically continues to reign until death, being unable to unilaterally abdicate for the tenets of constitutional monarchy. Title I of the first post-Second World War examples of New Zealand's status as an independent monarchy was the alteration of the monarch's title by the Royal Titles Act 1953. For the first time, the official New Zealand title mentioned New Zealand separately from the United Kingdom and the other realms, to highlight the monarch's role specifically as Queen of New Zealand, as well as the shared aspect of the crown throughout the realms. The title at the time was Elizabeth II, by the grace of God of the United Kingdom, New Zealand and her other realms and territories, Queen, head of the Commonwealth, defender of the faith. Since the passage of of the Royal Titles Act 1974, the monarch's title in New Zealand has been Elizabeth II, by the grace of God Queen of New Zealand and her other realms and territories, Head of the Commonwealth, Defender of the Faith. Although the Queen's New Zealand title includes the phrase Defender of the Faith, neither the Queen nor the Governor-General has any religious role in New Zealand. There has never been an established church in the country. This is one of the key differences from the Queen's role in England, where she is Supreme Governor of the Church of England, representation of the state. As the living embodiment of the Crown, the sovereign is regarded as the personification, or legal personality, of the New Zealand state, with the state therefore referred to as Her Majesty the Queen in right of New Zealand, or the Crown. As such, the monarch is the employer of all government staff, as well as the owner of all state lands, buildings and equipment, state-owned companies, and the copyright for all government publications. This is all in his or her position as sovereign, and not as an individual. All such property is held by the Crown in perpetuity and cannot be sold by the sovereign without the proper advice and consent of his or her ministers. As the embodiment of the state, the monarch is the locus of oaths of allegiance are required of many employees of the Crown, as well as by new citizens, as per the oath of citizenship laid out in the Citizenship Act. This is done in reciprocation to the sovereign's coronation oath, wherein he or she promises to govern the peoples of New Zealand, according to the respective laws and customs. Constitutional role. New Zealand's constitution is made up of a variety of statutes and conventions that are either British or New Zealand in origin, and together give New Zealand a parliamentary system of government wherein the role of the Queen is both legal and practical. The Crown is regarded as a corporation, with the sovereign, in the position of head of state, as the centre of a construct in which the power of the whole is shared by multiple institutions of government acting under the sovereign's authority. Though this power stems from the people, all New Zealanders live under the authority of the monarch. The vast powers that belong to the Crown are collectively known as the royal prerogative, the exercise of which does not require parliamentary approval, though it is not unlimited. For example, the monarch does not have the prerogative to impose and collect new taxes without the authorization of an Act of Parliament. The consent of the Crown must, however, be obtained before either of the Houses of Parliament may even debate a bill affecting the sovereign's prerogatives or interests, and no Act of Parliament binds the Queen or her rights unless the Act states that it does. Executive. The Government of New Zealand is defined by the Constitution as the Queen acting on the advice of her Executive Council. One of the main duties of the Crown is to ensure that a democratically elected government is always in place, which means appointing a Prime Minister to thereafter head the Cabinet, a committee of the Executive Council charged with advising the Crown on the exercise of the royal prerogative, and legally required to keep the Governor-General up to date on state affairs. In the construct of constitutional monarchy and responsible government, the ministerial advice standard is typically binding, meaning the monarch reigns but does not rule. However, the royal prerogative belongs to the Crown and not to any of the ministers, and the royal and viceroyal figures may unilaterally use these powers in exceptional constitutional crisis situations, thereby allowing the monarch to make sure that the government conducts itself in compliance with the Constitution. There are also a few duties which must be specifically performed by or bills that require assent by the Queen. These include applying the Royal Sign Manual and Seal of New Zealand to the appointment papers of Governors-General, the confirmation of awards of New Zealand royal honours, and the approval of any change in her New Zealand title. Foreign affairs. The royal prerogative also extends to foreign affairs. The sovereign of the Governor-General negotiates and ratifies treaties, alliances, and international agreements, on the advice of the Cabinet. The Governor-General, on behalf of the Queen, also accredits New Zealand High Commissioners and ambassadors, and receives similar diplomats from foreign states. In 2005, the letters of credence and recall were altered so as to run in the name of the incumbent Governor-General, instead of following the usual international process of the letters being from one head of state to another. In addition, the issuance of passports falls under the royal prerogative, and, as such, all New Zealand passports are issued in the monarch's name and remain her property. Parliament. The sovereign is one of the two components of Parliament, but the monarch and viceroy do not participate in the legislative process save for the granting of royal assent, which is necessary for a bill to be enacted as law. Either figure or a delegate may perform this task, and the viceroy has the option of deferring assent to the sovereign. The Crown is further responsible for summoning, proroguing, and dissolving the House of Representatives, after which the Governor-General usually calls for a general election. The new parliamentary session is marked by either the monarch or the Governor-General reading the speech from the throne, as the both are traditionally barred from the House of Representatives. This ceremony, as well as the bestowing of royal assent, takes place in the Legislative Council chamber. The monarch has formally opened Parliament on 5 occasions: January 1954, February 1963, March 1970, February 1986, and February 1990. Despite the sovereign's exclusion, members of Parliament must still express their loyalty to her and defer to her authority, as the oath of allegiance must be recited by all new parliamentarians before they may take the seat, and the official opposition is traditionally dubbed as Her Majesty's loyal opposition. Courts. The sovereign is responsible for rendering justice for all her subjects, and is thus traditionally deemed the fount of justice. However, she does not personally rule in judicial cases. Instead, the judicial functions of the royal prerogative are performed in trust and in the Queen's name by officers of Her Majesty's court. The monarch is immune from criminal prosecution, the notion in common law being that the sovereign can do no wrong. The monarch cannot be prosecuted in her own courts for criminal offences. Civil lawsuits against the Crown in its public capacity are permitted. However, lawsuits against the monarch personally are not cognizable. The monarch, and by extension the Governor-General, also grants immunity from prosecution, exercises the royal prerogative of mercy, and may pardon offences against the Crown, either before, during, or after a trial, is the judges and courts of the sovereign's judges and courts, and as all law in New Zealand derives from the Crown, the monarch stands to give legitimacy to courts of justice, and is the source of their judicial authority. The arms of Her Majesty in right of New Zealand is always displayed in New Zealand courtrooms. The Crown and the New Zealand Defence Force. The Crown also sits at the pinnacle of the New Zealand Defence Force. The Governor-General is Commander-in-Chief, and under the Defence Act 1990 is authorised to raise and maintain armed forces, consisting of the New Zealand Army, Royal New Zealand Navy, and Royal New Zealand Air Force. The sovereign's position as head of the armed forces is reflected in New Zealand's naval vessels bearing the prefix Her Majesty's New Zealand ship, and in the requirement that all members of the armed forces swear their allegiance to the sovereign and his or her heirs and successors. The Governor-General commissions officers to command the forces. Saluting of these individuals by soldiers is, besides a sign of personal respect, an indirect salute to the monarch and her authority, though the monarch and members of her family also act as colonels-in-chief of various regiments in the military. These posts are only ceremonial in nature, reflecting the Crown's relationship with the military through participation in military ceremonies both at home and abroad. Various regiments have also received a royal prefix, such as the Corps of Royal New Zealand Engineers, the Royal New Zealand Infantry Regiment, and the Royal New Zealand Army Logistic Regiment. One particular area of note is that the country's only currently ranked Admiral of the Fleet is Prince Philip, the Queen's consort. This title is held in conjunction with those of Field Marshal and Marshal of the Royal New Zealand Air Force. The Crown and Maori. Maori interaction with the Crown dates back to 1832, when King William IV in his British Council appointed James Busby as resident, to address concerns on the part of Maori in the Bay of Islands over expanding European settlements in that area. On the 28th of October 1835, Busby oversaw a hui held at Waitangi, at which a flag was selected for New Zealand and a Declaration of Independence written by Busby was signed by 36 Maori chiefs. Both were acknowledged the following year by the King in a letter from Lord Glenelg. As a result, the Declaration's ratification by the House of Commons in 1836. Officials in the Colonial Office determined in 1839 that a treaty of cessation would need to be signed with Maori for the British Crown to acquire sovereignty over New Zealand. The Treaty of Waitangi was signed in 1840 by representatives of the British Crown and over 500 Maori chiefs, and is considered the founding document of the nation. The treaty identifies the Crown's right to Kawanatanga governorship, leading one Maori academic to argue that Kawanatanga, or the New Zealand government, is party to the treaty. Since the treaty's implementation, a number of petitions have been made by Maori directly to the sovereign in London, whom they felt they had a special relationship, the first coming from Northern chiefs in 1852. This and all subsequent appeals were directed back to the sovereign's New Zealand ministers for advice on how to proceed. The results were not always favourable to Maori, who have communicated their discontent to the monarch or other royals, in response to a refusal by the Executive Council in 1981 to allow Mana Motuhake direct access to Queen Elizabeth II. Maori activist Dan Mihaka offered a traditional rebuke by baring his buttocks at Prince Charles and Princess Diana. In a later incident, Mihaka attempted to crash into the Queen's motorcade. He was intercepted by police before this happened. In the Maori language, the Queen is sometimes referred to as Te Kotuku Rerengatahi, meaning the white heron of a single flight. In Maori proverb, the rare white heron is a significant bird seen only once in a lifetime. In 1953, for her coronation, Queen Elizabeth II was given a Kiwi feather korowai, or cloak, which she wears when attending a pōwhiri, or Maori welcoming ceremony, also speaking partly in Maori. Cook Islands, Niue, and the Territories. The Sovereign of New Zealand also serves as the monarch in the Cook Islands and Niue territories in free association with New Zealand within the larger realm of New Zealand. The New Zealand Monarchy, however, is unitary throughout all jurisdictions in the country, with the headship of state being a part of all equally. As such, the sovereignty of the Cook Islands and Niue is passed on not by the Governor-General Parliament of New Zealand, but through the overreaching Crown itself as a part of the executive, legislative, and judicial operations in all three areas, though singular, linking the governments of New Zealand, Niue, and the Cook Islands. The Crown is thus divided into three legal jurisdictions. The Queen's representative serves as the Viceroy of the Cook Islands and the Governor-General of New Zealand. represented by the State Services Commissioner, represents the Queen in UA, carrying out all the monarch's constitutional and ceremonial duties of state on her behalf. The Administrator of the Territory of Tokelau is appointed by the Governor-General of New Zealand in Council, at the recommendation of the New Zealand Minister of Foreign Affairs, and the Governor-General of New Zealand serves ex officio as Governor of the Ross Dependency. But, as the territories are not sovereign entities, the Administrator and Governor are representatives of the New Zealand government and not the sovereign personally.